Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Welcome back. You know, it's been a while since we had a recording, and you're probably wondering what happened to my voice. November and December have been a little difficult for me. As a lot of you know, San Antonio has just been swept through with all sorts of viruses. I know that COVID has been on the rise. A lot of folks have gotten the flu. I think I've gotten a couple of those things since Thanksgiving. So it's been a little bit of a healing process for me. I don't know if it's a sign of getting older. I've just had a birthday since the last podcast interview we've had. Regardless, I'm excited to be back on. Thank you all so much for continuing listening to Beyond the Gavel, and know that we will continue to be producing these interviews and these episodes for a long time to come. Here's an interesting topic. In the latest season 6 of I Am a Killer, which is found on Netflix, episodes 1 and 2 entitled A Mother's Choice, that case was taken from a series of trials that we did in this court sometime back. I don't know how long ago it's been now. I remember the cases very, very clearly. The local media termed the case as the barbecue murder trial, because the idea was a gentleman was murdered. The body then had been cut up and burned in a barbecue pit in a backyard. So it was a very heinous allegation at the time. Netflix came in, contacted me, asked me if they could record from inside of the courtroom. I said, sure. And when they were done, they left. They did take pictures of my desk, and I think someone said there was a shot of me from a distance. I haven't yet seen the episodes. I'm sure I'll find the time at some point to do that. But if you're interested in observing a case that yours truly oversaw a few years ago, I think you'd get a lot out of it. Today, we're going to have a great conversation with Ken Good. Now, Mr. Good graduated from Hardin-Simmons University in 1982 with a Bachelor's of Arts degree. He received a Master of Education degree in 1986. Just so you know, Mr. Good, that's the year I graduated from high school.
Oh, I hate you already.
He got his degree from Tarleton State University, a part of the Texas A&M system. Now, in 1989, he received his law degree from Texas Tech School of Law, where he was a member of the Texas Tech Law Review. Mr. Good has argued cases before the Supreme Court of Texas and the Texas Court of Criminal Appeals, along with numerous courts of appeals, including the United States Court of Appeals for the Fifth Circuit. Mr. Good is married and has 2 daughters. Welcome, Ken.
Thank you. That's probably the most important thing right there, is I'm married and have 2 daughters.
No, you sound like a man that knows of everything in your life. You know, I did a podcast interview with you.
Almost 2 years ago, April 2023. I just looked it up.
Almost 2 years ago on the Bell Post. That's the name of your podcast. I had a great time coming onto that podcast. I think we had just started Beyond the Gavel a few months before. We had a really good conversation about bail and how the system works in Texas.
It was 2 years ago almost, and, a lot's happened since then, with the election that we just had, and, a lot's happened in the last week or so since Trump has taken office. So it's incredible. I had a podcast that I did probably months ago that I couldn't get released. We tried to release a link to the story, and it kept getting deleted on social media. And I was like, what is the deal? I've never really experienced that, whether it's being fact-checked or suppressed, whatever you want to call it. But now that the election's over, suddenly that's not happening anymore, and we released that podcast yesterday. So
very nice.
Crazy.
Was that on the Bell Post?
It was, and it was about, I found an article on the internet where it was saying that, California legalized marijuana and the cartels have stepped in and taken over the industry. And so I don't know why that I mean, so of course, when it got deleted, I was like, well, maybe I've been duped. And, after we recorded the podcast, I didn't realize until just recently, we got the reporter that wrote that article was a highly respected journalist. And so who has a lot of political connections. So, and he just agreed to be on our podcast to talk about his article. And he's probably been wondering, why doesn't Ken ever release that thing? So
that's an interesting topic. There's a lot that has been going on in the last several months, particularly related to information and how information is getting out. And our topics, right? We're going to talk about more than one thing, are related specifically to information and how a lot of the parts within the criminal justice system are really used for political purposes and used in a way to politicize certain agendas. And I know, you and I have talked about bail and the way it works in Texas, and both sides, if you're looking at the left and the right, have looked at bail through a political lens and have tried to politicize it and try to use figures in a way that's a benefit to those agendas. Let's talk about the reality of it. What's going on with bail and the way bail works in Texas and the criminal justice system?
Well, the reality of bail, I quote this former judge who was on a News Nation town hall. It's like, until you get an alternative to the private surety bail system that has the same low failure to appear rate and the high level of accountability, you don't have an alternative. And that's really where we are. Mm-hmm. We've been trying all these alternatives that have a much higher failure to appear rate, and that bogs down the courts. And we already have record backlogs because of COVID. So it just makes it worse. So, I mean, the reality is we just don't have an alternative. Now, Texas has kind of gone different than the rest of the country. Mm-hmm. In their bail reform, they've strengthened bail by limiting the use of the alternatives in violent offenses and by, increasing accountability. So I think they've actually gone the opposite direction of the rest, some of our more, I guess you would say liberal states.
Well, now, local media outlets, specifically one in San Antonio, really attacked me some years ago and other judges for working within the system. And look, the way I look at it is like this. A good judge is one that says, you tell me what the law says exists. You give me a statute. We will work within the framework of that statute. And bail, cash bail, surety bonds, that is a part of our system that judges have to work within. And so judges back then thought that those criticisms were unfair. Let's talk about bail. What exactly is bail for those listeners that are not quite sure what we're talking about?
Probably the biggest misconception is, you hear, they've got a presumption of innocence. Well, bail doesn't have anything to do with guilt or innocence.
Right.
Bail is what assurance you're going to give the court that you're going to return to respond to the charges that have been filed against you. And it's what assurance that you're not going to be, that you're going to appear, but also what assurance so you're going to give the court that you're not going to be a risk to public safety, because, there's all kinds of factors that you have to consider, but one of them is their criminal history. Mm-hmm. And so I think that's the biggest consideration. You got to make sure they're not going to be a problem to the court and to the public safety. And I think where you and your brethren got attacked years ago was we were at the start of this push, and the assumption was, well, everybody wants to resolve their criminal case and they don't need bail and they're going to come to court anyway. And that's been proven since then that that's absolutely wrong. During COVID, we found that if we don't have bail, people will not come to court. And if you enact these stop and release or cite and release policies, then they're going to see that as a green light to commit more crime. And that's exactly what's happened in the interim. There's been more crime going up, especially in the states where they have gotten rid of all accountability.
So let's say somebody gets arrested, right? Let's say, somebody gets arrested for an aggravated robbery, right? That's an aggravated felony where somebody displays or uses a weapon in the commission of stealing from somebody's person, right? But by force, obviously. And then so they get arrested. Let's say the police get those individuals, arrest at the scene, take them downtown. They go before a magistrate. The magistrate reads them their warnings. Part of that magistration process is to set bail. What are some of the factors that a judge or magistrate is looking at when they determine what the appropriate bail is for a situation like that?
Well, the charge, is one of the considerations, as you know. The factors that are set out in 1715 of the Texas Code of Criminal Procedure. Their ability to pay is one of the factors, but it does not trump the other factors. I think their criminal history is probably the most important factor. I think that was the biggest change that the legislature made in SB 6 two sessions ago. And there's other factors, but you know them probably better than anybody. And when you're looking at setting bail for somebody, to me, the most important thing is, what's your criminal history, or do you have one? Because I don't believe that someone with no criminal history is languishing in jail anymore. I mean, we hear all the time, low-level offenders can't afford bail and they're languishing in jail. That's not true for first-time offenders. But the reverse is, if you've got a criminal history and so you've proven you're a risk to public safety and bail is set what you can afford, well, you're not in jail because you're poor. You're in jail because you are a risk to public safety and you're a risk to not coming back to the court.
A big part of the 1715 factors are related to safety to the community, right? So if you're dealing with an offense that in and of itself is defined as an aggravated felony or an aggravated type offense, something where somebody was seriously injured or they could have been based on the weapon that was used or displayed, then that obviously is a very important factor of whether or not the community is going to be safe with this person out while their case is pending. Other factors like ties to the community, right? Things like, how long have you lived in San Antonio? Do you have a job? How long have you had that job? Do you have family? Those types of factors are also equally important. But the bottom line that the magistrate or the judge is trying to figure out is, what can we do to ensure this person's presence in court each and every time we have court? That's the issue. Right?
Absolutely. And, you would think that the more severe the felony, the riskier the bond is. But if they don't have any ties to the community and their ties are actually in a different state, that misdemeanor is a very risky bond, because if they go home to their home state, generally Texas doesn't extradite for misdemeanors. So we can't make them come back. And so within the industry, if we're not going to make them come back to Texas and they flee the state on a misdemeanor, that's the riskiest bond there is. It's just it's a lower cost usually.
Now there are different types of bonds, right? You have PR bonds versus
you have cash bonds, you have personal bonds, and you have surety bonds.
Exactly.
Which one is the only one that's protected? Which one's the only one protected by the Texas Constitution? The only one that you can't change without a constitutional amendment is the surety bond, because the Constitution says everyone, unless it's a type of crime listed in the Texas Constitution, has a right to bail with sufficient surety. Well, that's the private industry.
Right.
So we're the only one protected in the Texas Constitution. And I know we're attacked, but we should be celebrated. It's the only type of release that the government cannot take away from you without amending the Constitution.
And the issue with bonds in and of themselves are like anything within the criminal justice system, right? The law basically requires that we do not use cookie cutter approaches across the board on every single type of case, right? So, for instance, if we have a DA, and this existed here, we have a prosecutor that says every single person that gets this type of charge should be released on a PR bond. Well, what you're doing is you're using a cookie cutter approach and saying, regardless of why this person is committing an offense, let's say the person is committing criminal trespass. That was really the big one back in those days. Some people are committing criminal trespass because they are, let's say, homeless and they have no place to go. Some people because they have drug addiction issues. Other people because they have a mental health diagnosis that is so severe that keeps them living on the streets. Others for other reasons. There could be a dangerous individual who is committing that charge who then is taken in. And does that mean that every single person must be given the exact same type of bond because of the charge? And the answer is no, it should not work that way. Our system is founded on discretion and applying factors to each individual case based on those facts. And so I think that was a big issue.
In fact, that's the whole purpose of the criminal justice system in Texas. We want to impose individual assessments or individual determinations of what's going to make you productive. So what's a punishment for me or what's a punishment for you should be different. And, you call it a cookie cutter approach. I call it a charge-based system for release, where the same charge gets treated the same way. Everybody gets a personal bond. But the problem is organized crime, gang members, career criminals, they figure out how to make millions of dollars on those approaches, because when you treat everybody the same, even the person that's a first-time offender offender versus somebody who has 20 prior arrests. Well, the person with 20 prior arrests sees that as a green light to commit more crime as long as they stay within that little area.
So talk to us about PR bonds and surety bonds and cash bonds. Explain the differences to our listeners, sort of as a setup to where we go in our conversation.
When you set a bond, that's $10,000. So there's three types of bonds that can be posted. Cash bond means that someone has to post $10,000 cash. Now, it can be a family member, it can be a charitable organization like a charitable bail fund, or it can be a surety bond, which is the private industry, and that's where a bondsman in Bexar County is someone licensed by the Bexar County Bail Bond Board and authorized to post bonds. So they post a bond with the sheriff's office, agreeing that if the defendant fails to appear, they're going to get him back, or they're going to pay $10,000 to the county. Right. And then there's a personal bond. And the difference is that a personal bond is just the promise of the defendant that they will pay the county $10,000. And in Bexar County, have we ever seen a personal bond prosecuted for forfeiture where they've actually paid it? Probably not often, if at all.
No, I don't think I've ever personally seen that. No.
And so it's just their personal promise. I mean, if you got a cash bond or a personal bond, you're relying upon yourself for the most part to remind yourself when your court date is, and you're just pretty much on your own. But when you got a private surety, you're checking in with them. They're making sure you're doing what you're supposed to do, and they're reminding you of your court date. So it's kind of like somebody's holding your hand and making sure you go to court.
Mm-hmm. So then what happens, let's say somebody posts the bond or they post the dollar amount, whatever it is, they don't appear in court. Versus they show up to court every time case is now concluded.
Well, if they show up every time, then the case is resolved. Either they're found guilty or they're found innocent, but the bond is discharged once they're sentenced. And so that would be true for all three bonds. But if they fail to appear for court, then you would enter a warrant and you would enter a judgment nisi. And when that judgment nisi, or when that failure to appear occurs, then that kind of starts a timeline for the bail bond company, the surety bondsman. And they have strict timelines where they have to get the person back, or they're paying the full face amount of the bond to the county. So for a misdemeanor, we have 6 months to get them back, to get their case back on track, to get justice for victims, or on a felony, you get 9 months. And, one of the things that I think we're facing with this new legislative session is, what are we going to do with all these immigration people that we're all saying we're going to deport? And what happens if someone goes through your court, they get a large bond, and then it's posted, and then they get deported? Because under current law, that's not a defense to a bond forfeiture. But we know that the criminal case can't go forward without the defendant. So that's one of the questions I think we're going to have to address this legislative session, is if we're going to be increasing deportations and the criminal case cannot go forward, well, then why are we going forward on the bond forfeiture? I mean, bail is not supposed to be a revenue generator for the county. So we're going to be probably addressing issues like that.
Yeah. So what you're saying is, let's say somebody is charged with a crime, whatever that crime is, they post bail, they're out, they're intending by every stretch of the imagination to show up to court. Immigration authorities step in saying, hey, we're going to deport you, completely unrelated to the criminal case, just based on your immigration status. They get deported. Now, obviously, that person isn't here to take care of their case or to see their case through. What happens to that, right? What happens to that money that's been posted?
Because if the court sets a hearing, then they're going to fail to appear because they're out. But the problem is the case can't go forward. You can't finalize the criminal case, and so your choice for the criminal case is either let it sit, which OCA doesn't like to do that with your statistics. They want to see cases get resolved. So there's pressure to dismiss the criminal case, but there's also this pressure of, what are you going to do on the bond forfeiture? Are we just going to try to collect it? Because there's not a defense unless the bonds company files a 1716 affidavit before deportation, or files a request for a warrant under 1719 of the Code of Criminal Procedure, and then gets them back. I mean, you're going to be stuck with a request to pay the whole bond forfeiture when the criminal case can't go forward.
And even then, it's still up to that judge, right? A judge could still say, no, I'm not going to grant you any sort of an increase or a forfeiture or a warrant. The person hadn't had court yet. When the person shows up to court,
true. But
they come.
Yeah, I mean, you could do that. But I think with the new push for deportation, and we'll see how that plays out. I mean, you're going to see a push and pull from both sides. I mean, victims are going to want justice.
Right.
So they're going to say, well, justice to me is not deportation. I want my pound of flesh. But once they get deported, what does that do to the criminal case? If it just said, hey, if you get notice that they've been deported and you have to dismiss the criminal case within 30 days, then that would probably resolve the bond forfeiture, because that would be a mandatory remittiture. So I don't know. I don't know what the right answer is on that, really.
Now, the law in terms of state cases, other than a capital murder where a judge makes a finding after hearing evidence that death is more than likely going to occur, there's actually a standard called proof evident that a jury is going to sentence an individual to death. Beyond that, every single person charged in Texas with a crime has right to bail. Is that right?
Well, there's probably a couple of more broader things, like a third-time felon can be held without bail, but you've got to meet certain requirements.
That's based on the newer law, right? That came through a couple of years ago. Yeah.
Yes.
Yeah.
But one of the things that's kind of surprised me, because we're talking about the Texas Constitution, is can a magistrate or a JP deny bail? Even for someone charged with a capital offense? Because I've been to hearings at the legislature where the president of the JP Association was saying, hey, all we do is set bail. We can't deny bail. But there's like 4 different categories of charges that a judge can deny bail on. And one of them says only the district court judge can do it. And so their interpretation of that is from a case that's interpreting that one grounds for denying bail, not the other 3. One of the other 3 says a magistrate, and then the first one about capital murder that you mentioned doesn't mention any judge. So I would argue, and I've taught judges, that I think they're being taught incorrectly. I think that only bail by a district judge can be denied by that one offense that is authorized under the Constitution. But the other 3, I think a magistrate can deny bail. And so I think they're being taught incorrectly.
So when we're talking about bail, right, we're talking about somebody getting arrested, judge sets a bail amount, then somebody posts that, they don't appear, the county could then take that particular amount of funds that are listed or that are filed within the county registry for purposes of this person getting out on bail. What types of cases do we see in general folks not appear to court? In general, what is it that we see these failure to appear rates come from?
I think that's a good question. I think that it's across the spectrum, because, I think that the more personal bonds you use, then the more failure to appears you're going to have, because again, they're problem children. They're having to keep up themselves with their court dates. They don't have anybody reminding them. So I really think it's across the spectrum. The more personal bonds you use, and the more private industry you use, you're going to have fewer failures to appear across the spectrum too, because the industry has like a less than 10% failure to appear rate. And, cash has probably a 25% failure to appear rate, because somebody in the family usually puts that up. So there's pressure on them. But when you get to personal bonds, there's 50% failure to appear rate. And, according to Harris County Court Watch, looking at 2 years worth of data in Harris County for misdemeanor courts, it's an 80% failure to appear rate. And I did a podcast with a DA in California where they use a simple release like personal bonds for all misdemeanors across the state. He said they have a failure to appear rate of 80% for all misdemeanors in California.
Harris County does something similar to that, right? They have like an automatic bond that goes out to certain misdemeanor offenses.
Yes. So they're following a settlement in the O'Donnell case, O'Donnell versus Harris County. Even though the case has been reversed and the Fifth Circuit ruled eventually that it should have never been filed in federal court, they're still following the settlement because nobody will petition to have it vacated. And the settlement is that if you're charged for one of these 7 or 8 charges, which is pretty much 80 to 90% of all charges, you're going to get a personal bond of $100 without review of your criminal history. So it's a charge-based review. And so that's where we've kind of had problems with accountability. You've got defendants getting 17 personal bonds and failing to appear, and they just keep getting them like one after the other like candy. And that's the reason why we have problems. In Harris County, I looked at a docket, a report for a month just to see what the misdemeanor cases, how they were resolving them. Over 90% were dismissed.
So what's the answer? What's the best way to handle these kind of situations? Let's use a nonviolent misdemeanor as an example.
Well, but what I'm going to say is I don't have a problem with someone getting a personal bond, especially on a first-time offense. But if they fail to appear for court, why are you going to give them something that they've already failed with?
Mhm.
I mean, they already have shown that they're a problem child and they need more um, oversight. So I would say if you fail to appear, you're not going to get another personal bond. And, as you know, when they fail to appear, you have the ability you have new powers that you didn't have before. So once there's a failure to appear, you can limit a future bond to cash only. Or if somebody requests a warrant, then you can limit a future bond to cash. And we're not having enough of that. I think the lessons of all of these crazy bail reform mechanisms. We have a case called Sanchez versus Alabama, where they had to live under a preliminary injunction for 4 years, where they had to release everybody, misdemeanor and felonies, and couldn't hold them accountable. If they failed to appear, they had to give them another one. And so they had to do that for 4 years. And of course, crime was going up. Well, they eventually won. It got reversed. And so they got to re-implement a system of accountability. And if you didn't show up for court, there were consequences. And what do you know? Shock of all shocks. Within 6 months, crime started going down.
Mm-hmm. Well, I'm enjoying talking to you, Ken. Let's go ahead and do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to the Q&A break. We have a question. Why is there a 48-hour time constraint for people who go missing? What if it's a child? Well, that's a good question. I don't know if legally there's anything in the law that says that there's a 48-hour time constraint to report a missing person. You should always report a missing person as soon as you think that person is missing, without any sort of time constraints. I think the idea is the first 48 hours tends to be thought of as being a very critical time period, where the idea is if the police is unable to find somebody within a certain period of time, then anything could happen. So I think those first 48 hours are crucial. I guess the idea would be don't contact the police unless you think somebody is really, really missing. And sometimes people overshoot or they panic initially. But in reality, I think if you speak to any police officer, a deputy, any law enforcement agent or officer, I think they'll always tell you should always report somebody missing as soon as you think that they're missing. I think it's always better to be safe than sorry, especially if it's a child. If it's a child, you should report them as soon as you can, whether or not you think they're missing. It's a good question. Make sure to keep those questions coming. We enjoy answering them on the show. Head over to beyondthegavelpodcast.com to send in any questions that you might have. Now let's head back into the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to the show. I'm here talking to Ken Good. Statistics are interesting. It depends on who you talk to, right? Sometimes I hear or read about statistics that discuss crime going up in certain areas and certain segments of society, and then other folks use statistics that say crime is going down and look at all these great things that we're doing to change that whole dynamic. What's the reality of it? What's going on with crime in America today?
This is an issue I've looked at extensively since the last time we talked. In fact, probably in October, I wrote an article questioning, because, I've done debates with the Civil Rights Corps, which is filing these lawsuits across the country, seeking to impose bail reform. And they are kind of parroting the national Democrat policy on crime. It's like crime's not going up, crime's going down. Just look at the FBI statistics. So we've got a perception issue, not a reality issue. So I wrote an article. It was published in the Attorney at Law magazine saying, I question the FBI statistics. I don't think they're right. Here's the reasons why. The CDC tracks murder, and that it's substantially higher from the CDC than what the FBI is saying. The FBI's changed their system, and so compliance is voluntary, and they don't have enough compliance, so it's incomplete. And there was other reasons as well. Well, 10 days after the article was published, the FBI quietly changed their data and suddenly showed that crime was up. And so, the arguments that the reformers have been arguing for years based upon the FBI crime stats was completely destroyed. And so what did they do? one of these groups published an article the next week with their fallback position. And their fallback position was, well, bail reform and criminal justice reform is not the cause of crime going up. And I'm like, crap, bull. This is what we've been saying for 2 or 4 years now. Probably 4 years now. This is just simple criminology, what we teach in our college classes. We know how to handle crime. We know how to decrease crime. What we've been pushed through these reforms are things that have never been tested. And the reports that they rely upon are from other think tanks that are like-minded, and they call them studies, and it's not based on science. And what do you know? It's been a bunch of cooking the books is what I think. And I think it's been some suppression of news.
Mm-hmm. Another way that I found interesting, and I've talked about this in some of my classes that I teach, the way that the different reports related to crime statistics are compiled are also very different, right? So the big one is something that we call the UCR, which is a Uniform Crime Reporting System. And this system is compiled by the FBI, but they really just focus on the 8 major types of offenses. Think of like burglary, vehicle theft, murders, things of that nature. Whereas the other statistics use a different way to report, or maybe they'll put the first offense charged and then, or the higher offense, and then list all the others in a way where when you compile those different types of statistical categories and then report them, the numbers can look very different. Is that something that you found in the research that you've done as well?
Yes. And what I really found was, the FBI changed their form or the way they were collecting that data, and it required the local police companies or police departments to get new machinery. And so there was, at the time I first looked at it, the 2 largest police organizations in the country, New York and probably LA, were not even reporting under the new system for the FBI statistics. And probably the biggest thing, and probably it didn't go anywhere because Trump cited it, but the DOJ does victim surveys, and they've been doing them for 20 years. But if you look at that data for this year, it shows crime up like 40%. It's substantial. And so you can't reconcile one method that they've been taking crime statistics saying it's up 40%, and then the CDC murders up 20%, and then look at the FBI and say, oh, it's down. Oh, well, no, look at, I think probably one of the best statistics that probably doesn't have any politics in it is car thefts, because insurance companies require a police report before they're going to pay off a claim on a carjacking or theft of a car. And those are really bad. They're just awful.
Then each side will use the statistics that's a benefit to them to make their argument. How is this used in the bail process? How is this used with advocates and proponents related to bail?
Well, okay, so the federal government and the advocates would say crime is not up. So all this bail reform, like decriminalizing theft in California under $950, it's working. It's not increasing crime. Mm-hmm. Now, it may look like it is, but that's a perception issue. But you can believe us, crime is not going up, because look at this study that our think tank did, and look at the FBI statistics. And so the FBI statistics show crime is down. And so that proves that you shouldn't listen to Ken Good. That's what they would argue. And I did a debate with, I've already mentioned, I did a debate. Well, I eventually, got to the point where I was like, you can believe your eyes, or you can believe, this stuff that just is contrary to everything that we're seeing.
Uh-huh. What about violent crime, right? What is, statistically, how is violent crime currently in the U.S. compared to how it was a few years ago?
Well, the big problem is it increased during COVID. Mm-hmm. It probably increased, what I've seen is it increased like 40% during COVID, but then now it's down 20%. So they celebrate that it's down 20%, but it's still up 20% on a net since 2020. That's just crazy. Uh-huh. And but that's cooking the books too.
Mm-hmm. That's interesting. So, in terms of bail and bail reform, we talked about how 2 years ago the legislature met, and there were some major bail reform packages that were passed through the governor. And so, what's going on now? What's going on? The legislature just started meeting about a week or so ago in Texas. For 6 months, they'll be coming together and coming up with new laws. And the governor has indicated that bail reform was a big part of what they were going to try to look at this cycle as well.
So is the lieutenant governor.
What are some of the things that they're talking about?
Well, I think what they're referring to, their number one push is a proposed constitutional amendment to expand the use of preventative detention in Texas. I think that's what they're both the lieutenant governor and the governor are referring to. And that's been filed. It's been filed. Senator Huffman, who I think is probably the most powerful senator in the state right now. But she's a former judge, former district attorney. I don't know if she was a district attorney or worked
Out
there.
of Harris
but
County,
she's,
right?
yes,
Yeah.
and she knows it backwards and forward.
Yeah.
But she's already filed a proposed constitutional amendment. This will be the third session, I believe, maybe the fourth, that it's been filed. And, it requires a 2/3 vote in the House. And the question is going to be whether the Democrats and the Republicans can get along long enough for it to pass. And so far they have not been. And I don't know. I mean, it's too early to say. I think that they're going to be fighting all legislative session in the House. So far, we've had the fight over Speaker. So they're still fighting over what is going to happen. And right now, I think that under the rules that passed, we're not going to have any Democrat chairs, but we're going to have Democrat vice chairs of committees. And so the question is whether the Republicans are going to see that as a slap in the face to the Republican power. And we'll see.
Well, when you say local control, what you're talking about, there are 254 counties. Each county has a bail bond board, which is composed of, generally speaking, a district court judge, a county court judge.
12 or 13 people, but it's not every county. If your population is over 110,000, then you are a bail bond board. And if you're under 110,000, then you're a criminal code county. You're just what the law was before the bail bond board. You can decide in your discretion to become a bail bond board, and like Wise County, and there's counties that did that, and they can't go back once they do. But the majority of the counties in the state of Texas are criminal code counties. Bail is governed by the sheriff. So we have local control in those counties by the local sheriff. And then in the larger counties, we have control by the bail bond boards, which is made up of a board of 12 to 13 people. Takes 4 people to show up for a meeting, for a quorum. But the bondsmen have a representative, the defense attorneys have a representative, and then it's a spectrum of elected officials.
Well, so we know then that these types of things are litigated. They've been in the media quite a bit. The legislature is really focused on it. Locally, local powers are focused on the issues of crime and crime data and statistics. And how has the news cycle muddied everything? How has that kind of affected our perceptions as to how we see crime and punishment in Texas?
Well, my concern is that we're being attacked on so many different levels. I mean, we had a recent attack or comment to the legislature saying if they can't, if a state prison can't hire enough people to work there, they should close it. Well, then that limits our capacity. And anything that limits the capacity is a indirect push for bail reform. That's what's going on in California. I mean, you can say they're decriminalized. I mean, everything in California is because they have a limit on how many people can go into their state prison, and they won't build additional capacity. So whenever they pass the bills, call into the Safe Streets Act, that's all a smokescreen to get more people out of prison because they don't have the room and they won't build additional space. So we're seeing some of that, but I think in Texas right now, I mean, we're seeing more of a push. The pendulum has swung too far to the left, and now it has started swinging back to the right. And when it gets too far to the right, the push is going to be to hold everybody, preventative detention. And just like when it gets to the far left, the public won't stand for the crime increase. When it gets to the far right, the public won't pay for the capacity that it would need to hold people. Because, like in the federal system, they do a release or detain, and they hold like 75% of the people pre-trial. Maryland is tried to go to that type of system, and they did an interim report, and they're already up to holding 60%. I mean, can you imagine your jail in Bexar County where you were holding 60% of the people pre-trial? The taxpayers would never be able to pay for that.
No, and what's difficult too is that during COVID, the governor actually shut down a lot of state prisons, which then shifted a lot of the costs of the county. And our county taxpayers are already at the edge, right? There's not a whole lot more that they could spend in terms of incarcerating folks or holding people in custody while their cases are pending. Now, you mentioned 75% of folks in the federal system are held pretrial while their case is pending and not released. There was an argument that I heard yesterday. Myself and a group of other folks took a tour down to Harris County to see how they do their magistration process, trying to get some ideas as to what we can incorporate here in Bexar County. And the gentleman over there was making the argument that that system is better, no cash, right? That it's the way the federal system works. They do not use the surety bonds the way we do in the state. That somehow or another that's better. And I told him, hold on a second. I feel like almost every client that I ever represented in federal court when I was practicing could not get released. And these are people that are just accused of crime. These are not people that have been proven to be guilty, but these are folks that are waiting a year, 2 years while their cases are pending, and there's nothing that they could do with their lives.
That's right. My wife is a staff attorney for a federal judge. And she agrees that, and mostly, a lot of it's drug cases, and you don't want them released, because if they get out of jail and they violate their terms of release by going back and using drugs, they're going to get revoked, and then they're going to lose points on their sentencing report, and they're going to be in a worse position. But all of that is to say the federal government has a strong accountability element. The problem is at the state level, when you're holding that many people, you're losing accountability because you just can't afford it. I mean, you look at where Bexar County is right now. You're not holding 20% of the people arrested. Double that and double it again, and you can't afford that. And so you're forced to do simple release on all low crimes. You're really essentially giving up on misdemeanor crimes. And so that means all of the misdemeanors today is the training ground for tomorrow's felonies. And also, I think when you say that, there's only been one state in all these different bail reform measures that actually tried to set up a system that replaced the bail industry. And it's called the New Jersey plan, and where they set up a statewide pretrial service department. It was so expensive, they had to do a statewide tax increase just for that, and it still ran out of money. So, probably the only thing that's close to being the equivalent of what the bail industry does is Washington, D.C. And I did a podcast with their former director, and he said, look, if that had to be passed today, it wouldn't pass because it's so expensive. You just can't afford it. And so the only reason why it's there is because it's been there so long. And there's been no state since the New Jersey plan that has proposed as an element of reform that we're going to set up a statewide pretrial services department. And so what you end up replacing the private industry with is just personal bonds. So they're just getting released with no oversight, which that we know what that does. And so, of course, they're going to argue, oh, we like that system, but Harris County doesn't have it yet. And they're still, they're shipping so many people to multiple locations for their jail because, they enacted a local rule for their bail bond board that on a list of violent offenders, the bondsman had to collect 10% of the face amount of the bond before they could post the bond. So, their jail is full of people that would be willing to make payments on bonds, but they can't because of the local rule of the bail bond board. And the reason why they enacted that local rule is because the judges won't hold the defendants accountable. So they're having to go around them and set up these rules. If the judges hold them accountable, I keep saying our good friends on one side of the spectrum, if they could have gotten a lot more mileage on their reforms if they just put a strong accountability element into their proposal. They would have worked a little bit better, but because they didn't, they're going to have a backlash for probably a couple of election cycles.
Yeah, and apart from all that, right, we know that statistically our caseloads in a state court for the criminal type cases are 97, 98 times more caseloads on the state side than we do on the federal side. So we just have so many more cases that are pending that there's no way we could hold all these people pre-trial. That wouldn't make sense. So
no, and if you, look at what your caseload is. Well, look at your caseload now. If you were to just say, all I'm going to do is give personal bonds, you'd have to have twice as many courts at least, because your failure to appear rate is so much higher. And so, I mean, people don't realize, changing to something that's really not a true alternative because the failure to appear rate is so much higher.
So how can we bridge this gap, right? With these countervailing perceptions of crime and punishment, statistics up or down. How do we bridge that? How do we reconcile those statistics to get something that is a good, true version of where we're at?
Well, I think it's going to be difficult because we have these advocate groups that are not compromising, and they just have all kinds of money. I mean, look at what's going on, in Harris County. There, Kim Ogg was a Soros-supported DA, and she went to these seminars, and she finally said, "I don't believe in this stuff." And so they said, "Well, then you're not liberal enough." And so she wasn't invited back. And then in the primary in March, she had an opponent that they gave $2 or $3 million. Now, $2 or $3 million in a primary for DA is an ungodly amount of money, and he won easily. But so when you're elected by these groups, then you're invited to seminars, and the seminars, they tell you, this is what we expect because we elected you. You no longer will do enhancements on crime. You will no longer seek long sentences. You won't no longer prosecute minors as adults. And it goes on and on and on. And then they have these groups that issue studies that say that you're to release to the public that says, by doing these new policies, it will not increase crime. Here's a study that says that. And then the final groups give you press releases. I mean, Kim Ogg was upset when she lost, but she did a podcast with me where she laid it all out. And since then we've discovered there's books that they're not secretive about what they're doing. I mean, they are influencing criminal justice across the state. And that's in the most recent election in November. More than half of the candidates supported by those groups lost. And there's more work to be done because they're being replaced with law and order new DAs. And so I think the pendulum has started to swing, but it's worse than just influence. I mean, they're misrepresenting the statistics, like you said, until, I've said that for a while, until we can, compromise is where you meet somewhere in the middle, but when they're not willing to agree that there is a middle, that it's their way or the highway, it's hard to find a compromise when they're essentially misrepresenting the facts.
Yeah, there's some stats I read. 70% of crimes are committed by 7% of defendants. That's amazing.
Yeah, because and I know that in our, in like San Antonio, there's a small group of people committing a lot of the crime.
Mm-hmm.
Then you've got, imagine what would happen if we concentrated on accountability on those 7% instead of doing the cookie cutter stuff. And we said, you got a substantial criminal history, so we're going to treat you differently because that's the way the criminal justice system was built. And crime would go down. Even if it started out with we were holding more people, it would go down because so much of the crime is being committed by that group of people. And we've been sold a bill of goods for a while, and I think that's ending.
So it's just a pendulum swinging? Is that kind of how you look at it, right? You go, which is sort of the way the American legal system has always worked. It goes to one side, and then there's some corrective action that's taken, but it's like generally has a tendency to overcorrect. And as a result of that, the pendulum swings. Then you see problems going on in that whole area. So that's kind of where we're at. We're kind of going back to the whole law and order kind of a concept, right?
Well, and I would even say we are making the same mistakes that we made in the 60s. In the 60s, we felt safe. We were more forgiving on our criminal laws. Crime started to increase. And on the political spectrum, one side refused to participate in the fix, caused a backlog. And I didn't learn this till last week, but the reason why we had this push to fix it was from our minority communities because they saw that it was doing greater damage to their communities than to the public at large. That resulted in Reagan getting elected and the war on drugs. So we're now in the middle. I would say we're in the middle of the backlash has happened again as a result of feeling safe and having these lax policies pushed even further to the laxness nature of them because of these advocates on one side of the spectrum. And so now we've had a backlash, and I think that the backlash will last longer because the damage has been hidden for longer.
I can definitely see that. Let's talk a little bit about the Damon Allen Act. This is the SB 6 that you referenced earlier,
Yes,
and that I was talking about that required some changes in the law. This actually changed the way PR bonds can be used. Do you see an expansion of that this next cycle, this next term that the legislature is meeting now?
Yes. I mean, Senator Huffman filed a bill last session to add some additional offenses, like a felon in possession of a gun is not entitled to a personal bond, and some other offenses. But that bill did not pass. There was it got bogged down in a fight between Senator Moody and Senator Huffman. And so I expect she will file another bill, and she will renew that part. So yeah, I mean, the Damon Allen Act had several major parts. The first one, I would say, reviewing criminal histories. But the biggest part of that was the public safety report system, because we didn't have a way to review the criminal history, so they had to set up a system to display it for the judges. So all that's part of reviewing criminal histories,
especially in smaller counties.
Oh yeah,
right.
Yeah.
In smaller counties, they didn't really have an ability to look at somebody's entire history like we did in Bear.
That's right. We just looked at their history in that county. We have tried alternatives to bail multiple times in our history, and there's a reason why the private industry has been around for 200 years, and it's because it does one thing and it does it very well. It gets people to go to court. And until there's an alternative, again, going back to what the former judge says, that has the same level of accountability and the same low failure to appear rate, we don't have an alternative. Advocates for change can say there's alternatives. They can argue that people want to go to court anyway, but history has proven that just absolutely wrong, especially during COVID. So until we have some alternative that meets the same requirements as the private industry, we don't have an alternative. And the private bail system will continue to operate because that's all we have.
Yeah, because you're making folks financially responsible for getting somebody to court. Right. That's what a surety is. There's some arguments. I had some students, and, back in the day, 5-6 years ago in class, there'd be a class that I would teach, and, they would ask me, what do you advocate for? And I'd say, look, I'm a judge. My job is not to advocate, and ethically, there's an issue that I have with advocating, because I'm supposed to follow the law, and I don't want to be termed as being unbiased, or I don't want to be termed as being biased if a case comes before me that I've advocated some change in the law. Right? A judge's job is to basically focus on that law. But then when the students would tell me we should do away with all cash bail, I'm saying, okay, I'm not arguing with you, pro or con. What do you do about the serial rapists of children? What do you do about the murderer? What do you do about those types of offenses? And then the argument turns into, well, we should keep those people in custody, like the federal system. But then it's like, now you're making a determination that just being accused is going to keep you in custody for a very significant period of time.
Well, we're going back to what we were before the Magna Carta. Accused of a crime, you get held.
Right. That's exactly right. Because back then, right, the idea was if a grand jury brings a case against you, then they're looking to keep you incarcerated for political purposes or other types of purposes. And you always want to keep those types of issues out of the justice system. Nobody has the exact same motivation and intent when committing a certain particular offense. Everybody is a different person, and the effect is different across the board. And as a result of that, we definitely need to be looking at cases on a case-by-case basis and not use approaches that basically will create these vacuums where people will fall into and become hostage to, because it won't be appropriate in every situation. So
I had somebody tell me recently, we shouldn't have elected DAs, and, they say we shouldn't have elected judges. And I'm like, the problem we have is there's politics in everything. And so I don't know a better process, but I don't think we should get away from electing judges and electing DAs.
And it keeps things more transparent, right? I mean, by elections, people have the ability to see, ask questions, obtain knowledge. There's some statistics across the board where jurisdictions that appoint judges, those appointed judges don't do a better quality of work than those that are elected. Elected judges are just as good or better, according to across the board cold statistical facts as to how judges handle their job. So it's a difficult argument to say that you're taking politics out of the process if you don't elect judges, and those judges somehow or another are better. So,
but then you're making politics in the picking of the judges, not the election of the judges.
That's right. And if that were the case,
and so it's not transparent.
No, and if that were the case, somebody like me, grew up in a certain segment of society that is not as well off as a lot of others, would not have had the opportunity to have been a judge. I never would have been selected, just based on my background, I think. So that's the nature of it. That's how it works.
Well, and I like the idea of elected judges because, I look at, people like you and me who were very poor families growing up. And going to law school was
right.
A dream. It was never a goal. It was a dream. And so I had to realize that you have to work for your dreams. You can't just have a dream. So I had to turn it into a goal. And that's the reason why I got a master's degree before I went to law school, is because my grades weren't good enough, but I made it a goal to go to law school. And then when I got there, I flourished. There's people that did really well in college, but then they kind of don't do as well in law school because everybody there is smart. Everybody is just brilliant. And it just gets on your nerves sometimes how smart people are there because everybody's that way.
That's what I tell my former classmates. That's what I tell them. Hey, so talk to us about your podcast, The Bell Post. What do you talk about on your podcast?
Well, all we do is talk about criminal justice issues. And we've been doing it for 4 years now. So we're starting season 4.
Mm-hmm.
We have a whole spectrum of guests, like you. We have guests from judges to get insights on setting bail. But we also, I like to do podcasts about case law that, when a new case comes out, I like to write an article about it. So I like to talk about stuff in the past, how the court decided the case. And then, so, we've done multiple articles and podcasts on the O'Donnell case, but then we'll do something on studies. Like we did a podcast on a study early on about why people languish in jail. And so we go from trying to learn about bail in different states, trying to learn about how Texas operates, why crime is increasing, studies, why this study is incorrect. And I did an article that I wrote about the FBI statistics. And so we just keep doing that. I think the most recent podcast that we did one of them was we talked to Kim Ogg, and she told us about the Soros stuff. That's going to be released next week. And so we just keep trying to educate the public on criminal justice reform, but, continuing to grow, get better, and trying to, hopefully we'll run out of topics one day when we get this pendulum swings back and we settle down for a while, and then we'll start swinging back again, hopefully after I retire.
Well, our interview, first of all, hopefully you don't retire anytime soon. I always enjoy talking to you. And so our podcast discussion from your podcast, The Bell Post, that episode is listed on our webpage. It's a new webpage on beyondthegavelpodcast.com, but you got to click on the more section at the bottom of at the top. Actually, the more is at the top. So click on there and you could hear one of the most iconic interviews I think that you've probably given. I've enjoyed talking to you, Ken.
I've enjoyed talking to you again. It's always great seeing you. And I think that we have similar, you're a lot smarter than me, so I like to grow in my knowledge.
I don't know about that.
But I really hate to find out that I'm older than you.
No.
I'm not, I don't dye my hair, but I keep thinking I should because when I get out in the sun, it's all gray, but I don't care. I'm just going to get old.
I'm going to say, if you look at these screens, no, I don't think anybody would guess that at all. And like I said, I just had a birthday since the last podcast interview. So I'm feeling a lot older. So I'm 57 now. So I'm feeling that.
So I'm fixing to be 64 in March. So
wow.
Yeah.
Well, we'll keep up the good work. Keep up the good work.
All right. Well, hey, it's good to see you.
Likewise. We've reached the end of this episode. Thank you so much for listening. Don't forget to subscribe and keep sending in those questions. Remember that you can now text the show by clicking Text the Judge to send in your insights, reviews, and questions. I'll mention them during the break. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.